Morning. Well, good afternoon, everybody. Sorry, to the next session for the Human Rights and Housing series. We're in workshop 2, which is the levelling up. We've tried to make that a intermediate level. My name is Charlotte Beaumont-Field, and I'm the Community Sector Officer, Development Officer for Human Rights at QCOS. And I'm very pleased to have you all join us today. So I come to you from Meanjin, Brisbane, and I acknowledge the traditional custodians of the land on which we are facilitating this webinar today, the Turrbal and Jagera peoples. I would like to pay my respects to elders past and present and emerging. I especially welcome and pay respect to all the First Nations people joining us on the line today. It would be wonderful if you could take a moment to use the chat function and let us know from which lands you are dialing in from. We always get a lot of registrations for these events, which is great to see, and we get registrations from all over Queensland. So if you could share, it's a lovely way to give us an idea of the breadth of our country and connection to land of our First Nations people. Lastly, I'd like to acknowledge that we meet on stolen land as sovereignty was never ceded. Thanks, everyone. That's great. Thank you for letting us know where you're from. So I'm just reading my chat function to see where everybody is. Secondly, I would very much love to welcome the facilitators and contributors for today's session. I've got Alex Ladd from Caxton Legal Centre, Bridget Cook from the Queensland Law Society, Rachna Nagas from the Queensland Law Reform Commission, Louise Ariaza and Tile Emo from QHRC. Thank you so much for your immense expertise in these areas. It really is a privilege to have your time and contributions today. Sorry. Right. So some of you may have joined us on our first workshop. No problem if you didn't have the chance, but I'll just spend a couple of minutes going over our first workshop. So we explored the purpose and scope of the Human Rights Act and became familiar with the 23 sections. We learnt some essential terminology and concepts related to human rights law. We started to discover how the Act can be applied to your own organisation, whether that be developing different policies or procedures or understanding how to advocate for your clients using the Act. And we also started to have a look at the Human Rights Compatibility Assessment, which again is a great tool, not only for public entities, but for the community sector to assist in making decisions for your workplace in terms of services offered to clients and that sort of thing. So just a quick recap. These are the 23 rights that are protected under the Act in Queensland, and the rights that are particularly applicable to the community sector work, which Section 17, protection from torture, cruel and inhumane or degrading treatment. Section 25 is privacy and reputation. Section 27, cultural rights, and 28 is cultural rights of Aboriginal and Torres Strait Islander people. Section 36, right to education. And people, regardless of citizenship, have rights, not organisation, governments and other businesses. We're talking about individuals. So, as I said, all individuals in Queensland have human rights and only individuals have human rights. And the Act strives to recognise the inherent dignity and worth of all human beings. So it's really good to understand, why we have this we have this legislation. We're using it as a, you know, a discussion tool, like a measurement stick. You could, when you're creating new policies and procedures, or you're making decisions in your own workplaces, you have that act to have there always in your mind, to make sure that your decisions that you make in your workplace connect with the Human Rights Act. So it's a really good, you know, tool to be using in this space. We learned last time about the evolution of the Human Rights Act in Queensland. We know that it's a fairly new piece of legislation, passing 5 years ago now. It came from all the atrocities, I guess, from World War II in particular, where the world said never again are we going to experience the kind of torture of thousands of people that we did during World War II. Australia has signed most of the existing international human rights treaties, but it is only when those treaties are incorporated into domestic legislation that it can be properly protected. So Queensland was the third state or territory to introduce human rights legislation in Australia. The ACT introduced it in 2004, and then Victoria in 2006. And as we know from last time, each of the acts are based on the dialogue model, which is each arm of the government taking responsibility. So we have Parliament who make decisions, make laws and decisions in that respect. We've got the public entities who put laws into action, and we've got the courts and tribunals who interpret and enforce the law. But between the human rights must act as a foundation for decisions, for new pieces of legislation, for any amendments of legislation and that sort of thing, and delivering those laws. So the police, etc., have certain obligations under the Act to abide by those, the 23 sections of the Act. So the Parliament are required to consider human rights in the development of new laws. Courts are required to interpret legislation consistently with human rights, and public entities must make decisions and act consistently with human rights. So it is a process, it is a discussion, and each arm of the government must adhere to those sections of the human rights. So just quickly, and I will bring Bridget in a minute, the Human Rights Act was developed against the backdrop of the win by the Labor Party in 2015. The passing of the Act was in part a response to a grassroots campaign coordinated by the Rights for Queenslanders Alliance, or the Alliance you may have heard them referred to. So that movement was supported by 43 community organisations and thousands of Queenslanders. So this has been ongoing since, you know, obviously since the end of World War II, and Premier Frank Nicklin introduced the first bill to provide legislative powers and protections for human rights in 1959. Bridget, do you mind if I call on you just briefly to, Bridget was involved in the campaign for the Human Rights Act, and I just thought it would be a lovely little little discussion to have about her contribution to the movement.
Charlotte. Hi everyone, my name's Bridget and I'm a policy solicitor that works with the Queensland Law Society. For those that may not be aware, the Queensland Law Society is a peak representative body for solicitors in Queensland. So we're kind of uniquely positioned to provide independent and expert insight on law reform that affect the rights and freedoms of all Queenslanders. I personally wasn't around in the early stages of QLS's advocacy in relation to a Human Rights Act in Queensland, but I am aware that as early as 2006, the Law Society was a strong advocate for introducing a statutory framework to clarify and provide enforcement around human rights and a requirement to consider them in decision making, particularly in the context of law reform and lawmaking. At that point, we didn't have a human rights and public law committee. So a lot of the Society's advocacy work is based on consultation with its membership. And one way of doing that is through the legal policy committees that we support and draw upon for their expertise in these significant law reforms. So back when there was an initial committee inquiry, QLS consulted widely with its membership, probably potentially we had about 12,000 members at that time, and put on a fairly substantive submission that was informed by, at that time, a human rights working group. Following the advocacy that was driven by that working group, we then provided more substantial submissions once the bill was introduced that sought to advocate for the need for a clear and enforceable rights protection mechanism in Queensland, how important it was for creating transparency and accountability in public decision making, and to improve outcomes, particularly for those experiencing disadvantage in our community in Queensland. So following that working group and the bill being introduced, we then formally recognised our Human Rights and Public Law Committee at the Society, and they've been a huge source of expertise to the Society when making submissions regularly in response to inquiries that enliven the human rights considerations and implications for legislative reform. And Rashna and Alex, who are also here today, are members of that committee and have a huge wealth of experience, and really glad that they could join us as well.
Me too.
Thanks, Charlotte.
Thank you, Bridget. Thank you very much. It's really important, I think, to understand that this was not something that was just easily implemented. It was a journey. It had some setbacks. It was largely connected to, the political climate at the time of those discussions. So it's, nothing's perfect, but I'm very proud to be living in a state, a part of Australia that has fought for and now has a Human Rights Act. I think it's really important. All right, which brings us to workshop 2. So now we want to explore the understanding of how the Act applies to decision making and service delivery, and to explore rights limitation and proportionality in practice. So we need to, I guess, what I'll be babbling on about for the next little while is rights limitations, how it's a bit of a push and pull dynamic between some pieces of legislation and the Human Rights Act, in how rights can be limited under certain circumstances, and I guess understanding the background of why some human rights are limited. It's good to understand that. So we'd love if you could, if after this workshop you feel a bit more confident in identifying and addressing human rights impacts, and again have a look at the Human Rights Compatibility Assessment, or the HRCA, which is again a process for determining whether a particular decision is compatible with human rights. So it'd be wonderful just to break the ice a little bit to use the chat function, or if you're brave enough, you might want to raise your hand to talk about how you currently use the Act within your organisation. So you may use it to, when you're writing. You may be working with tenants who have had their human rights limited and they don't understand, or you feel that they are limited unjustly. You might want to take action by writing to the person who or the organisation who was responsible for limiting those rights, you feel, and discuss the particular sections of the Act that have been limited, and use that in your advocacy. Yes, Wendy.
Hey Charlotte, how you going?
Hi, I am
I just
going well.
I just thought I'd share we include the Human Rights Act just as part of decision making, whether
Perfect.
that's around allocating properties or especially at a potential end of a tenancy, like if there's a breach or a notice to leave process, we include those reminders about human rights compatibility checks
Yeah,
as part of the checklist for that process,
yeah.
just to ensure that staff are actually saying, what sections of the Human Rights Act are you considering when you're making this recommendation, just to make it more practical in a day-to-day sense. We do that.
Yeah, no, that's perfect. It gives, I find, and hopefully you'll agree with me, that it gives you some reassurance as well that you're acting, you've got this piece of legislation, you are doing the right thing, you can justify any actions needing to be taken. It promotes discussion between yourself and your colleagues, and that sort of thing. So yeah, I'm really happy to hear that that's a part of your decision-making processes.
Yeah, and it's an important act to make it a regular discussion topic with staff, so it does normalise it and make it a living part of that process. Yeah.
Yes,
Yep. Cool.
living part, that's good. It's not like, yeah, it's an interesting act because it can have, can be limited. So, but it does promote discussion and it does, I guess, hold people accountable before they go ahead and make decisions or introduce new policies and procedures in their workplace, just to make sure that they're acting compatibly. So, all right. Anybody else? Okay. And I will have a spot for some questions as well for my facilitators or panel as well. So if you've got any questions that maybe don't quite relate specifically right this second, we will have an opportunity to discuss those. Right. So this is a quick overview of what we will be doing today. As I said, I will spend some time talking about human rights and human rights limitations. We'll then do a little breakout session again. If you participated in the workshop 1, you'll be familiar with this format. The difference with this one, though, I am giving everybody a break because 2 hours is a long time, and I appreciate that we need a bit of time. So there will be a break. And then the second breakout session, it's more of a discussion about, I guess, what we were just speaking of, using the Act in your community and how you can, I guess, support your sector, your peers, to use the Act as well. Then we have another Q&A session and then a summary of learnings, and I'll share some resources that you can explore after this workshop. Okay, so this is a lot of information. I don't want to just read this out verbatim to you. I guess what I'm trying to put forth with these slides is to show you that, as was mentioned, the Act is it's a living thing. So it's used in different ways to other pieces of legislation. So it is important to understand a few things. So the Act requires the Queensland Parliament to consider human rights when making laws, as we've talked about, and instructs courts to interpret law in line with human rights principles. Under the Act, compatible with human rights means an act or decision does not limit a human right or limits a human right only to the extent that it is reasonable and justifiable. So that's what I mentioned before. So we try and do, all we can to be compatible with human rights, but there are some instances where we just can't. Like children in, watch houses, for example, their human rights are being limited. They just are. So we can do other things to try and ensure that in those spaces that their human rights are respected as much as possible, but it is very difficult when the actual facility is human rights limiting. And I'll talk about some other examples later on. So the Section 13 of the Human Rights Act provides guidance on when human rights may be limited and the factors to be considered when assessing if an act or decision is compatible with human rights. So if you do have the Act handy and you haven't as yet, it is good to have a read through that section because it steps out, it's questions to ask yourself and the process to go through.
Yeah.
Just a reminder to pop your mute on. Thank you. Right, so human rights should only be limited after careful consideration and in a way that can be justified in a free and democratic society based on human dignity, equality, freedom, and the rule of law. So it is, yeah, they are something that, again, it's a breathing thing. It can evolve and change, but you have to, when you're advocating for a client, for example, and if you feel that a right has been limited in a way that can't be justified, then that's your platform for advocacy. So when you see a particular act, a particular human rights human right that has been limited, that's when you can act. That's when you can ask the person who's made that decision to justify why that decision has been made. So that gives a lot of power to your advocacy, is what I'm trying to say. So again, as I've discussed, the human rights compatibility assessment is a tool and process for careful consideration. So it should be part of your wheelhouse. Is there a law or regulation which allows you to limit a human right? So we know that there are. So Section 13 states that a human right may be subject under law to a reasonable limit. If you cannot identify a law or regulation, then you may not be able to limit the human rights. However, if yes, then you consider the following factors. Now, this is taken from the Queensland Government have provided this process, and I can send it to you all after this workshop finishes. It's a step-by-step guide. It is more user-friendly than just reading the legislation itself. So it talks you through your decision-making process and whether you're acting compatibly or not. But I just wanted to take you through, and my facilitators feel free to jump in and give some examples or some more context to what I'm saying. So which human rights are protected by the Act will be or are subjected to limits. So you've got to ask yourself, what is the nature of the human right to be limited? What is the purpose of the human right? And what are the values that underpin the right and what is its scope? So we're talking about how and when rights can be limited. It's a process, step by step, and there are questions that you must go through when you are making a decision or advocating on behalf of someone else, etc. Is the purpose of imposing the limitation consistent with the values of a free and democratic society? So what is the purpose of the limit? For example, does it address a specific area of public or social concern? Is it sufficiently important to justify that limit? So limiting some rights will require more justification than others. For example, limitations on freedom of expression will be easier to justify than limitations on the right to be free from torture. So, I mean, to be free from being tortured is an absolute human right that cannot be limited. So if you answer no to those questions, then the right may not be reasonable or justified. So again, we're asking ourselves questions, we're taking ourselves through the process. Is there a relationship between the law imposing the limit on the human right and the purpose of the limit? If so, does the limit help achieve the purpose? So we're talking about limiting somebody's human right. Does the limit advance the purpose it is designed to achieve? Is there evidence to support this? So we're looking at, is there research, is there, so I'll talk about an example next. Hopefully it's on the next slide. That'll give you some context. So we know that, we've banned, the Queensland government has banned smoking in or around public hospitals because it's got the clear purpose of preventing people from developing cancer, etc. So then they've obviously asked themselves, by limiting people's freedom of, to be able to smoke, that the benefit from limiting that human right is greater than allowing that human right, if that makes sense. So they're looking, is there evidence that banning smoking will achieve the policy's purpose, to prevent harm and such? Is there evidence that suggests smoking bans help to curb rates of lung cancer and other health issues? So a rational connection can be made between the purpose and the prohibition. The limit does not need to completely achieve its purpose or be the best way of achieving its purpose. If no to either question, then the limit may not be reasonable or justified. So in this instance, the majority shows that limiting a person's, right in this respect is not as great as the public safety and the health concerns. So that's an example of when human rights have been limited, but it has been justified. So is there a less restrictive and reasonably available way to achieve the purpose? Oh, sorry, Louise, I've just seen you. Would you love to step in?
That's all right. No, I just put my hand up. No, I just wanted to share that this happened a lot during COVID. So for us at the Commission, we received a lot of human rights complaints in relation to freedom of movement. Yeah. So I just wanted to share that was pretty common, and we receive a lot more complaints than we normally would because our movement was limited in order to protect people's rights of being healthy, right to health services. So
that was a big one. I think I may have mentioned that in workshop 1 because it's a clear, I guess some examples can get a bit muddy for people, but these, I guess when it comes to public health and safety, well, look, maybe it's just me, but I find them easier to connect with sometimes because it's sort of, there is evidence, COVID is spreading. We know that if we keep away from people with COVID, we'll limit that spread. Therefore, the right freedom of movement, is justifiably limited. So we can, justify it like that. So
that's right.
Those are clear examples, but thank you for popping in. That helps. Does anybody else have any examples of when, they've seen a human right justifiably limited? If not, that's fine.
Yeah, actually, I'd like to mention one, and I think what I struggle with is that I'm seeing one of my supported employees limited in their choices, but it's actually not an organisation holding them back, it's their own family. So it's a very, very hard boundary to work with. So, for example, the supported employee wants me to act and wants the advocacy, and then the moment it becomes concrete and there's going to be movement, the person then retreats and feels scared and then asks to stop, but that it is affecting their life. So I find that a huge challenge.
Yeah, it's areas, anything dealing with people and family and emotions and that sort of thing it's extremely challenging, especially, I can imagine. I don't know exactly what is happening, but yeah, I can hear your frustration. Rashna. Yes, you're on mute. You can unmute and join us.
So sorry.
That's okay.
I was just going to add one more to that if we have time,
Sure.
but I can save it for the breakout rooms otherwise.
No.
In the criminal law context, which might be different to everyone else's, experience here, but just for some variety of examples where there might be a justifiable limitation on someone's human rights is to do with whether or not they should be released on parole at the point of at that relevant point, which is a decision made by the parole board, which is an organisation under Queensland government. So that's another example of where human rights becomes a relevant consideration, where you have to consider whether or not it's justifiably limited or not, and you're dealing with freedom of movement, freedom from arbitrary detention versus the safety and protection of the community.
Yeah. Thank you very much. I think that's a very useful example. So there's lots of examples out there, and people may have come across them without really realizing where it fit, I guess, in the Human Rights Act. But so it's good to have these discussions to know that there's a process, and sometimes it's applicable and others not. All right. So again, continuing on in this limitation discussion, we've got another question to ask. Is the importance of the purpose of the law limiting the human right greater than the importance of preserving the human right in this case? So taking into account the nature and extent of the limitation on the human right. So you've got to consider whether benefits gained by fulfilling the purpose of the limitation. So, what's the point of the limitation? Does it outweigh the harm caused to the human right? So again, it's that dichotomy, push-pull dichotomy, that discussion. It's a real process to make sure that your human rights respecting. This is a balancing exercise, as I've just said, that involves comparing the importance of the purpose of the human right with the importance of the human right and the extent of the limitation to be imposed. So the more important the human right and the greater the incursion upon it, the more important the purpose of the limit will need to show that it is reasonable and I can't say it, and justified. If yes, then the limit on the human right contained in the proposal is likely to be reasonable, and that word justifiable under Section 13 of the Human Rights Act. So I would encourage you to have a look at these processes, and as I said there, I can send out the link in the post-event email, but it's just step by step takes you through, and it would be, if you're not already, implement into your practice to make sure that your organisation and how you conduct yourself in your organisation is human rights respecting. So I'm just going to recap, so make sure everybody's sort of hopefully on the same page. Use Section 13 of the Act to allow for limitations that are consistent with a free and democratic society based on human dignity, equality and freedom. And you do that using the following process. So you look at what is the nature of the human right being protected, what is the purpose of the limitation being proposed, what is the relationship between the limitation itself and its purpose. You need to explore whether there are any other options. Are there any other less restrictive and reasonably available options to achieve the same purpose? And how important is the purpose of the limitation balanced against the importance of safeguarding the human right? So this, in a nutshell, this is basically what Section 13 is assisting with. It's showing you the process and the procedure in terms of looking at whether a human right is justifiably limited. So the Human Rights Act cannot limit human rights protected by other laws and cannot create absolute rights, and allows for limitations consistent with a free and democratic society. Generally, rights are not absolute, that is, they are allowed to be limited, but only after careful consideration and only in a way that is necessary, justifiable and proportionate. Absolute rights include freedom of thought, conscience and religion, as well as prohibitions on torture, inhumane treatment and degrading punishment. Is that making sense to people?
Yes.
So, yes, we have human rights, but many are subject to limitations as long as they're justifiably so. And only after you can show that there's been careful consideration in terms of limiting those human rights. So here we are, quick pause for questions. So I'll open up the floor a little bit to see if there's any questions about what we've spoken about, or maybe something else that's bothering you that you'd like to ask. Or maybe from my facilitators or panelists, whether there's anything you might like to add about the limitation and compatibility processes. Charlotte stands alone. Okay, well, that's great.
I was just about to say, Charlotte, you're on your own. You're doing awesome.
That's all right. Well, that's good. It means I've done the job perfectly. Everybody understands the process. Everybody understands what rights can be limited. Maybe there aren't some that can't be, and how we all, yeah. Well, that's good. Great. I'm winning today. Okay, I did have a break scheduled for now. We're ahead of time a little bit due to my, I guess, excellence at presenting this. So we can, if people want to have a break now, we can, or we can proceed to run through a quick case study. So I realise
I'm happy to go ahead, but I'll leave that up to the majority.
How about my facilitators? Do you guys need a little bit of quiet time, or are you guys okay?
I'm good to keep going, Charlotte, if everyone else is.
Wonderful.
Same.
Okay, we'll just ignore this wonderful break time slide and go on to our case study. Okay, so in the pre-event email, you would have received a case study that we'll be doing in a breakout room, but I thought I would just go through one now for good times. Okay, so a man experiencing homelessness was living in his van parked in a council-controlled beachside parking area. So this is an actual real-life case study that had obviously went through a process, and a decision was made too. Yes, Rachna, I agree. We'll have a break after this. Okay, there were no parking restrictions or fees payable in the car park. This man chose the location because of its easy access to the toilets, which were open 24 hours a day, because he often needed to use the toilet, like because of a medical condition. So despite raising his medical issues with council officers patrolling the area, the complainant was given fines for illegally camping at the park. The fines amounted to $3,000, an amount which he could not afford to pay. People who find that, like, the fines given out for people in such vulnerable situations drives me a little bit crazy, but anyway, okay. So luckily this man had an advocate, and this man's advocate raised several human rights, including the right not to have a person's home arbitrarily interfered with. The man was experiencing strong pain when having to wake up frequently and drive to the toilets. He found interactions with the council officers embarrassing, quite understandably so, and he felt as though he wasn't being treated with respect. During the conciliation, the council stated that the man was in breach of a local law which had the important purpose of protecting privacy and safety in the community. Council officers expressed that they had sometimes ignored the man rather than fining him every time. The council also said that they had tried to link the man up with homelessness services. Does anybody have anything to add at this stage? This is quite.
Is there evidence? Is there evidence that the council tried to link the man up to homeless services, or is that just their
They may have done. They may have done. I'm not sure, and I don't know. And again, is that enough to justify action taken against him?
That's right.
To resolve the complaint, the council agreed to withdraw the remaining unpaid infringement notices. The man was reimbursed for the fines that he had already paid, and the council also agreed to undertake staff training on the Act. So this is quite a positive outcome, and this outcome was linked to the Anti-Discrimination Act. So the human rights were piggybacked onto that complaint under that Act. So the Anti-Discrimination Act, the laws that were contravened there was discrimination, impairment, and the relevant human rights were recognition and equality before the law, privacy and reputation, freedom of movement. So the man's advocate was able to identify the use of the Anti-Discrimination Act, plus added in the extra weight of the human rights limitations in their advocacy for this man. Yes, Emma, you had a question?
Yes. I suppose I had a couple of questions on that, which is, can this also be used in the case of tents and rough sleeping? Has this been used before for people getting fined? I know in Moreton Bay and the Gold Coast just started fining. And are we able to use a case study like this in terms of advocacy, or is this just purely just, I suppose, used for this workshop?
No, this is a real life example of something that actually happened and the process. So you're very much, and again, my panelists, my facilitators, if you can, because I'm not a lawyer, but so if you can jump in and add some weight to this. But it is something that I'm in favour of always advocating. So if you can if you've got the Act by your side and you're able to identify, and also, other pieces of legislation like the Anti-Discrimination Act in this case, to present as much weight to your advocacy as possible. I mean, what are they going to, they're not going to, it's only going to benefit the person. If no one does anything, then no one does anything. But if we can say, actually, hang on a second, this man is in a very vulnerable situation, instead of punitive actions, and maybe you've mentioned, maybe the council workers did mention a homelessness service, but beside the point.
Yeah, I feel like isn't the homelessness service and his medical condition like superfluous to the case study though? The case study is.
Well, the medical condition, you can use the Anti-Discrimination Act because of that medical, any kind of disability or anything like that, if that's in breach of that piece of legislation. But it is, they don't have to, if you present that argument with the weight of these pieces of legislation, not just the Human Rights Act in this case, but, it is always good to employ, if you can identify the rights that have been limited in your client's case, and you can use that in your advocacy work, I don't see you might get frustrated. Maybe they can show you how they've justified their limitation on that particular man's or your client's human right, but you can keep pushing it. You know what I mean? Maybe can they justify it? This the whole process that I talked through at the beginning. They've got to have certain they've got to go through certain processes in order to limit someone's human right. And if they can't justify that process and they can't show that it is of benefit to, I don't know, public safety or whatever they're trying to argue, then I don't see why you can't keep using those pieces of legislation to push and push and push and hold people who make these decisions more accountable. Because, this man is never going to be able to pay $3,000. And we know, when I worked in the community sector with homeless people and with young offenders for 20 years. And I know that, fighting and advocacy work is so important, and you use whatever tools that are at your disposal, and you hold the decision makers accountable. You want them to be able to justify any decisions. So I think it's, this is a great step forward. I mean, it's not a perfect process, but it is a great step forward in terms of adding more weight to our fight in our advocacy work. So, this was a real life case study. There are lots, the human rights that are being, I think, unjustifiably limited in our parks, and, you see tent cities and different things like that. It's really important to advocate for those people. Thank you, Faye. If everyone has had a look at the chat, Faye's put up an article from the ABC. And Belinda's asked if there's no, well, I think there's, from my knowledge, and correct me if I'm wrong, but there are problems. I know in New South Wales you can park your van and sleep in different places, but I think in Queensland there are bans on camping. It's like illegal camping or something like this. Is that right? Does people know about Rachna? You had your hand.
That's right.
Yeah.
Yeah, it's illegal to camp in Queensland, and sleeping in your car is counted as camping. Sleeping in a tent is counted as camping.
Yeah. So that's illegal. So that's why the council was trying to find the man, because he's homeless, but we've got this sort of, you're not allowed to be homeless law. You can be homeless sort of out of sight, I guess, is what we've got going on in Queensland. But I have a very good friend. He's decided not to. He owns a house but doesn't live in it. He's got this great van that he travels around in, and he lives in New South Wales and is able to do that. But up here, he's not. Rachna, did you raise your hand before? Did I interrupt you?
Oh, no, all good. I was simply just going to quickly mention to what Emily was raising, that the value of having a Human Rights Act in Queensland is that alongside any claim regarding that a particular decision was not made within the appropriate boundaries that exist under other laws like administrative law and things like that, where you can question a decision maker's decision, you can use this legislation as a supporting mechanism for that. And you can use that, as you were saying, at the stage of discussing with the decision maker before you take anything formally to court. So that's the benefit of it. It sort of builds that dialogue model further as well, in that people are talking about it and talking about everything from a human rights lens, which is always preferred, especially in the community space.
Definitely. Thank you, Rachna. I 100% agree. So yes, as I've babbled on about, it is a tool, it is a platform for creating discussions. It is a way to hold those decision makers accountable in terms of them justifying some of their decisions, and hopefully before lodging, formal complaints and things like that, there can be a resolution. Rachel, you've just come up in the chat. I'll take 2 seconds to read. It is hard. I mean, it's hard to meet human rights in a lot of different spaces, as I was talking about in the, the recent adult crime, adult time situation, and having more young people in watch houses immediately limits their rights. So the human rights space and its competition with other pieces of legislation it's an ongoing battle, but I guess at least we have this piece of legislation that we can use, that it is something that we can add more weight to our arguments, because it is, it is a process to implement the respecting human rights culture. And again, it is fairly new. I mean, it was only brought in January 2020, so people are still getting used to it. People are this is a new piece of legislation, and so people are still learning how to understand it, how it works, the discussion model. So, having workshops like this, I guess, and upskilling yourselves and talking to your peers and colleagues, we can try and do our best to navigate trying to implement the Human Rights Act in sometimes a very restrictive environment. Emma, sorry, did you have a question or a comment?
Yeah, I suppose if we had time, just on the IHR, I recently read the new policy for IHR, and it had said on there that it's gone through the human rights lens, all throughout it in the State of the Act, but it also applied other restrictions that are new, such as IHR is only available to citizens and not residents. I suppose why is that differentiation there? Like, why are we able to not admit someone to IHR because of that? And my second observation was that the IHR policy says that we can evict people from IHR or exit them from the services based on if they have, and the key word they keep using in the policy is alleged. They have alleged criminal activity. I suppose, where does that word alleged fall into this human rights, where it says it's kind of being applied here, but, who's alleging what? Is it the moteliers that are alleging? Is it the IHR staff within the homelessness service, specialist providers? Is it the police? And where does someone's rights come in, I suppose, in the right to free and fair trial, I suppose, in losing a service based on alleged activities?
I'm going to call on my panelists now, who are legally trained individuals. Does anybody have a comment or some clarification to offer Emma? Alex, do you have anything that you might want to add?
Sorry, I didn't mean to turn my camera off as soon as you said my name. That was not my
I didn't even
intention.
see. I didn't even see
meant
you
to turn my microphone on. Look, it's a very specific question, and I'm not going to. I don't know the ins and outs exactly that that policy you're talking about, but I guess it does go to the fact, even with the criminal record side of things, there was pushes to have that as a protected attribute in the Anti-Discrimination Act reforms that were unfortunately paused by the Queensland government. So even though that's anti-discrimination protection, it's not human rights protection specifically, there is that link there. But I guess sometimes even when there are those limitation on rights, service providers do use ways of sort of couching those in terms to sort of just slip it under another human right. So they might be using it in terms of that alleged criminal activity, which is definitely concerning, but it might be more about the risk to other people that that alleged activity could cause. It seems very speculative and quite concerning. Definitely worth actually getting maybe some advice or engaging with one of the services, like legal advice services, to get some information about that if you're concerned for some of your clients. But I imagine there's some other human rights that have attempted to engage there, potentially.
To add
like
context, I believe
that would be great.
Of Housing. It's Department of Housing policy for providing funding to an IHR program, which would go across the board to all IHR providers. So
what is IHR? I imagine many people know on this chat, but I'm not on this webinar, but I'm not quite sure what
IHR
I
don't know what it means either.
It's called an immediate housing response.
Okay.
And the immediate housing response is the money provided to homelessness service providers and community housing and social groups to provide motel management. So people experiencing homelessness, especially families and individuals, they can call up and the service will put them into a hotel for sometimes 3 days, sometimes an extended period in that program. And then they're supposed to, and there's other things involved in it, but I'm sure other people know a little bit more than I do. I don't work in IHR.
One thing I would say, especially because it's a Department of Housing policy as well, I know we've in the previous workshop and in this one a little bit, we've alluded to the statements of compatibility as well. So I'm not sure, are you referring to when you mentioned that alleged criminal activity, are you referring to that's what you read within the statement of compatibility? Because all public entities have to provide statements of compatibilities for decisions and things and their assessment. So it might be worth having a look.
No, it was a policy for eligibility into an IHR program.
It's worth pushing back against, and again, it's some advocacy. I hate to name you, but you're the person that's raised it. But I imagine there'd be other organizations that would have those same concerns, and they do have to have considered human rights. And simply just saying that they're concerned about that from a safety, let's just use that umbrella term, safety perspective, it needs to be a more clear balancing of the rights, not just saying there's a safety concern, but what about the impacts that the limiting of that policy has on other people's rights, like property rights, like their freedom from cruel, inhumane, and degrading treatment, their recognition and equality before the law, their privacy and reputation rights. They all need to be really balanced and not limited, in a demonstrably unjustified way. So I think it's really trying to maybe get some more information from the Department of Housing, because they must have done a compatibility assessment to make sure that their policy is in line with the Human Rights Act. So you could do some advocacy based on that, or engage a service to try and support you to do that, but it's worth doing.
And it's always worth questioning when you're reading something like that doesn't make sense, to go back to whoever issued that statement or that policy and just ask some more questions about it.
And you can always identify, particularly the key thing that we talked about last time and even this time, the big takeaway I think still remains is being able to really identify the relevant rights you think have been engaged. Obviously it's good to know how they might respond, but you've got a bit of that background of what their concerns are. But I guess from your advocacy lens, you're trying to identify, well, these are the rights that should be considered, and you don't believe they have been considered enough in the change to a policy. So trying to identify, which of the 23 rights are relevant, and sometimes it is the more the merrier, as long as they're somewhat relevant, or as clearly making that link as possible. But I'd encourage you to try and get some more information from them to understand why those limits have been made and why that policy change has occurred. I know it's a bit of a vague lawyer answer, but I'm a lawyer and I don't know all the details, but certainly there are avenues to try and address that, and they must comply with human rights in a policy. It's not just a decision to evict someone, it's the policies, it's the legislation governing them, it's all those different types of parts of public entities' work that need to consider and be compliant with human rights.
Thank you. I think the one question I think I was answered, and maybe I missed it, which is the difference between citizen and resident. Do we have a clear guideline that we can actually not have people who are non-citizens have human rights? Is that part of our system?
So certainly the Human Rights Act applies to residents in Queensland. It isn't just restricted to people who are full citizens. I don't know the specifics of that of which legislation or which policy it's covered, but often citizen and resident can be defined within legislation. But yet again, there needs to be a reason why that distinction is made. Otherwise, someone could make a discrimination complaint. They could raise arguments of human rights. So my understanding, and please facilitators absolutely jump in if you have anything further, but my understanding would be that it would seem unreasonable and a limitation on people's rights, and arguably discriminatory if there were those limitations or those specific requirements imposed. So I'd have to see the specific policy, but it seems a bit unreasonable. But
it does.
Other facilitators or anyone else in the workshop, feel free to jump in. But it seems unreasonable.
Thank you, Alex, for letting me call on you and throwing you in. You're just so good at it. Did anybody have any? Did anybody else have any other of the facilitators, my lovely famous five, have any contributions to what Alex added then?
Oh, look, I find, Alex, you just had me gripped straight away. You're so knowledgeable, and I would love if I had one-on-one with you to discuss my one case that I have, because mine's not based specifically on this type of case study. It's still to do with housing and having understanding for this supported employee about his rights. And I just want to know the best way to support him. But I've been advised that if he pulls out every time you get to that point where advocacy is about to start, they get scared. So I feel like I'm leaving someone vulnerable out there. So I think mine's a little bit more sensitive and maybe needs
I think potentially you should ring up some legal advice. I don't want to just, sorry, we're having
Yes.
a private chat, everyone, now.
Yeah,
But
no, I don't want
just
to
in terms
either.
of just a very, very brief summary, I guess that's more talking about his individual decision making. So while it's a
Yes.
right issue that he has that sense of autonomy, so it's not a specific, you know, it's those overarching rights. It's more about his ability to actually action his preferences, his wishes and preferences. And I guess you're talking about supported employment. So does
Yes.
the person have like a underlying impairment or disability as well, or just they have an over sort of protective family at
No,
times? Is that why?
they have a disability, but they're
Yeah.
very very switched on. Yeah.
Of course, it's just contextually sometimes those
Yes.
type family settings can intervene. But I guess it's trying to support that person to feel like they can make their own decisions, and it's easier said than done. But ultimately, that person is their own decision maker unless there's you know, some form of documentation in place. But even in terms of employment, usually you know, enduring powers of attorney things shouldn't have a say in those type of decisions. It's quite a specific decision. So ultimately that
Right.
person should be making their own decisions. So it's a rights
Yeah.
issue, but it's actually more framed as like a decision making issue. But I'd
Okay.
encourage you to ring up, you know, even you know, seeing if that person get their own advice, you know, from Caxton Legal Centre or something, or any other CLC as well. But it's certainly doing some advocacy to try and make sure that person is their own decision maker and can actually engage in the employment that they want to. I'm sorry, everyone, just a little tangent
Yeah,
there.
no, I'm not. Thank you so much.
All right, on that note, I will go back to my break time slide. So if we could come back about 2:10. Hello, everybody. Welcome back. It is now 2:11. So we've got to get through some wonderful breakout sessions. So for the first breakout session, we will be breaking into groups. We've decided to cut it a little bit shorter just because we're a little bit over time currently. So we'll just break out for maybe 15 minutes. And we will use the case study 2 that you hopefully received in the reminder email that was sent out recently, and got a worksheet called the Tenancy at Risk worksheet that was also sent out to you. And then after we have our breakout session with our facilitators, we'll come back and share some insights before we break again. All right, so hopefully hold tight. Each room will have 2 facilitators, so I look forward to seeing you soon. Sorry about that, everybody. We had some delightful technical issues on my end. I was sort of kicked out of my presentation and couldn't find my way back, but I am back. So, how did everybody go? Did any of the facilitators wish to share any feedback from their particular breakout session? We didn't really get a chance to look at the worksheet, unfortunately. We were discussing situations in which like other scenarios of people who maybe didn't have a child or didn't have some of the factors that this particular woman had. She had a reason for leaving her property. She had children with her, so but specific human rights were engaged as well.
I think we talked about the crisis,
and then
the
we
interplay with crisis responses as well. And I guess as well, we really highlighted that a lot of government decision making is discretionary, but housing in particular, because of the nature of whether someone is more deserving of housing, has been something that's been part of that type of decision making long before the Human Rights Act was in place in Queensland. It just provides advocates a bit more of a framework and a bit of a stick to use if decisions are made that you know, are unfavourable to clients as well. But particularly we reflected on, especially in crisis responses, it's really difficult and that balance becomes even finer often, whether you know, which rights need to be balanced to create an outcome that's, you know, proportionate and reasonable, consideration of an individual's rights and various other individuals' rights as well.
Yeah,
it's not easy.
Yeah, you've got the right of, you know, if this situation that we discussed in our breakout room was, you know, a woman without children who was leaving her crisis accommodation for set periods and she had somewhere else to stay. So a lot of crisis services, I know from experience, having worked in many, have a policy to, you know, sort of ask the person to leave, you know, officially, to allow people who are, you know, homeless and have nowhere else to go to take that person's spot. And so then there's that debate between the rights of that, you know, single woman who's leaving that crisis service for periods of time against the rights of, you know, people wanting to be housed.
You talked about including human rights in terms of like when you're setting up your policies as well.
Yeah.
It's always a really good backing. As Charlotte was saying, funding is a big thing about making sure you retain funding by following certain processes, but you know what your company's organizational vision is and your goals are, but also human rights is a really good framework to use to sort of back up those decisions. And you can be more assured of the decisions you make based on the policies being framed in those terms.
So if you set it up from the beginning, it's never going to eliminate all problems like this. But if you if you try, when you're making policies, when you're making decisions, to lay a good groundwork based on human rights, if you can do that, then hopefully it will lessen the frequency of such sort of conundrums in the future. As well as, I think it's really important to, in that situation where if it was a single mother, I'm sorry, a single woman who was just leaving and, you know, back and forth or whatever, to involve her in that conversation rather than just saying you've breached the policy, out you pop. It's more having, you know, that discussion, saying, look, you really want to, you've got the right to be housed, you've got the right to be safe, and, you know, but we are looking, this is the situation in which we find ourselves, and hopefully coming to a decision together with that person using the refuge. In terms of the scenario we just discussed then, I've just put up in the chat, the complaint was an Anti-Discrimination Act with the human rights piggybacked on. The human rights that were identified were the recognition and equality before the law, freedom of movement, property rights, and protection of families and children. So the outcome was that the tenant was permitted to be absent for longer than 5 months with certain conditions. Yes, Rachna. You're still on.
I did it again. Sorry.
That's okay.
In our group, we also talked about the right to education. Section 36, section 2 talks about every person having a right to access further vocational education and training that is equally accessible to all. So that doesn't necessarily mean just children, it's parents as adults as well. One of the group members raised that. I'm sorry, I can't remember your name, but thank you for doing so.
Yeah, that is I didn't think of it. What a facilitator I am. So yeah, that is a very good point. That is a very good point. Yeah, so hopefully you had a chance to look at the worksheet. It's this one without it going away. I don't even know if anyone can see that, but it's a good, it's called Considering Human Rights Tenancy at Risk. I will send out that one again and 2 others. It's I guess a simplified version in terms of making decisions in this space. You and your staff, colleagues can maybe use these or similar. You can, you know, adjust them to your own particular workplace to use as a way in which to make decisions around this sort of thing. They're really clear cut. They don't have you know, don't have a lot of legal jargon or anything like this. So they are good to use in terms of making decisions in a housing situation. All right, now looking at the time, so if we move on from meerkats to penguins, this is a good opportunity. This is obviously the breakout sessions are not recorded, so you may feel a bit more free to chat about some of the challenges in your own workplaces. And I'll yeah, I just welcome sort of, I guess, some feedback about maybe some challenges you've experienced enacting the Human Rights Act in your workplace, or and how you may have overcome some of those, getting some support from how you've helped your peers, whether they're, you know, in your own organisations or other organisations, sort of use the Human Rights Act in their practice. And I guess having a bit of discussion about what your workplace could be doing differently, or how you can make suggestions, I guess, in order to incorporate the Human Rights Act in a stronger way, possibly in your workplace. So hopefully you received those questions again in the pre-event email, but the facilitators may be able to pop them up into the chat, or yes, okay, so we'll break out for 15 minutes and then come back for 5, and then, yeah, start to wrap up the session. See you soon, everybody. Let's go on to what we talked about. Because I sort of dominated the last feedback session, does any other facilitator want to contribute what sort of, and with the contributors' permission, of course, any challenges or positive stories or anything like that that came out of their breakout session?
I'm happy to talk again if no one else is going
Alex.
to.
We had a good session, I
Yeah,
think.
we had a really good conversation with people. I wish we had more time. There were some
Yeah.
questions coming at the end there. Unfortunately, we didn't get to. But we did discuss quite a bit about, you know, the benefits of, you know, the Human Rights Act, and it does provide that framework for sort of, you know, putting a bit of a stick to agencies and to the Department of Housing. And sometimes, you know, discretion still plays a big key, and that balancing act is really hard sometimes. But there were some participants that were, you know, reflecting that they have gotten some good outcomes for some clients that they've supported, but sometimes as well it doesn't go the way that they think it will sometimes, and it is that there are more rights engaged and certain rights seem to get over the line, or certain you know, at-risk factors seem to get people over the line for favourable outcomes. We also talked about you know, broader societal issues and the multifaceted nature of the housing crisis we're going through. So the Human Rights Act, while it's a really useful tool, and there's some great handouts that Charlotte will send around to everybody, it doesn't solve every issue. And there's a lot of reasons in terms of government funding for services, government, you know, creation of appropriate housing, as well as various other, you know, things that put people at risk of experiencing homelessness or sleeping rough, that cause human rights issues. So unfortunately, the Human Rights Act just doesn't solve all the problems, but I think a few people have really reflected to us, and it's certainly my experience and my colleagues' experience, that the Human Rights Act is a really great tool and quite an accessible piece of legislation that doesn't require lengthy legal proceedings. Another person also reflected that it is able to be used, especially in those really short time frames where you can't wait for, you know, court processes and slow tribunals to accept, you know, applications. You need some legal backing straight away, and advocates are amazing at doing that. Support workers and the community sector are amazing at putting those support letters in, seeking some urgent action and urgent reasons as well. Reasons is a really good, Human Rights Act is a really good way of getting reasons from the Department of Housing as well. There's some quick reflections.
We spoke of, you know, if we're pushing back all the time, it you know, the more people who push back and advocate for their clients, the more that the decision makers have to take the time to actually really consider whether the decision they're going to make is human rights compatible. So because they know that now there's a tool that we can use to push back and say, actually, this decision, not so great because of this, this, and this, and this. So if we're all doing that and we're all pushing back, then the decision makers are they're going to expect some pushback if they haven't taken the time to act in a compatible human rights respecting manner. So the more that we push, the more that, you know, and they will have to justify their decisions. And if you can understand, you know, the process of, you know, making a decision in a human rights compatible way. So some of the things we've talked about today and in the first workshop, if you can understand that process, then you can hold them accountable still. If they come back and show you how they've justified a decision, you'll either understand that they've followed the process correctly, or you'll think, no, that's not quite right, and you can, ask for further justification or consideration, because the more informed we are, the better action we can take, and we're not ignorant to, and just being told that this is a decision that's based on this, off you go now. We can actually say, hang on a second, I do know a little bit about this now, and we are, using this tool, we are using the Human Rights Act. We know how we can use it to, how decisions are made, how human rights can be limited as long as it's in this particular fashion. So the more informed we are, the better we're able to advocate for our clients. And I know that, and somebody from our group, maybe Wendy, suggested that they use an anonymous way of communicating any particular things that they'd like to see in their own workplace. So instead of a suggestion box, it was a human rights box or something like that that people can put in and offer some suggestions. I know we're running out of time. Very sorry about this, but I will send out worksheets as well. Somebody raised an issue about if you have a whole lot of different sort of families or different individuals applying for the same accommodation, there's a worksheet that we have to help with deciding, I guess, which particular family or individual is offered that property. So I will send that out in the post-event email to everybody, as well as other resources that I might be able to think of that might be helpful. So again, we looked at the limitations and proportionality principle. Oops, I'll just go back. We looked at decision making and the Act, so holding people accountable who are making those decisions, as well as our own decisions in our own organisations in terms of policy creation and that sort of thing. And I encourage you to collaborate with your sector, interagency meetings and that sort of thing is a really good platform to talk about the Human Rights Act and how your organisation is practicing it, any challenges that you guys may have come across, and so forth. And as I said, I'll throw a lot of things into the post-event email, so you can use them hopefully in your workplace. Just quickly, we've got Human Rights and Housing, the third workshop coming up on the 10th of June, and that's all about complex decision making. So that's another step up from this one. And then I will be talking to the Human Rights Commissioner on the 8th of July as well, if you are able to come along to those ones. So those events will be, the links for those will be sent out. We've also, again, quick reminder, we've got our QCOS conference. I think registrations are open for that now, coming up on the 25th to 27th of November here in Brisbane. I'd like to thank the Department of Housing for funding this session. It's appreciated very much that we're able to have such forums and be able to discuss these issues with our peers and colleagues. I also wanted to thank all of you for coming along. Again, it's heartwarming for me to see that so many people are interested in, upskilling and sharpening their skills and learning in this industry, because I think we all want to do our best for our clients and for our organisation. And I want to thank my wonderful facilitators and panellists for, putting up with all my pre-event emails and my discussions and my requests and my and the time spent today I know you're all very busy, so just a big thank you to everybody, really. There'll also be a link to go out in the email, post-event email, about how you found this session and any feedback for future ones that I can incorporate. That would be tremendous. And if you have any specific questions for me, you can reach me at charlotteb@qcos.org.au. I think that's a wrap, folks. Thank you so much for coming. sincerely. It's been wonderful, and I look forward to seeing you at future events.